Hello, welcome again to another episode of Introduction to Philippine Criminal Justice System. I am your instructor for this afternoon, Criminologist Mary Joyce P. Malin, and I hope you are all doing well, safe, and healthy. And I will be continuing now the discussion of the um, the first pillar of the criminal justice system, which is the law enforcement pillar. But before we begin our topic discussion, let's have first a quick recap on what we had discussed on our previous meeting. So last meeting, if you already saw my video presentation before, I had already uploaded the part one of the presentation, and one moment. All right. So, just a quick recap on what we had discussed last meeting. We have discussed the definition of law enforcement agency and policy, the evolution of policing in the Philippine setting, the Philippine National Police, its powers and functions in connection with the criminal justice system, the concept of police service, police community relation, and other terms related to COPS, the theory of police service, the police discretion, the criminal investigation, custodial investigation, the overview of NBI, and the other law enforcement agencies. So, I have already uploaded my video presentation for part one episode, and I would suggest that you should watch it first. If you have not yet watched it, uh, uh, watch it first before you proceed to these topics so that you will be able to understand more how the criminal justice system works, particularly in the law enforcement pillar. So let's get started. So we will have the part 2.2, law enforcement pillar. So the content of my presentation this afternoon are the following: the definition of arrest, the manner in conducting arrest, the warrant of arrest, its requisite and exemption, the rights of the arrested person, crimes committed by police officer while conducting arrest, search warrant, the requisite of a valid search warrant, the search and seizure, subject of search warrant, when to serve search warrant, the distinction between warrant of arrest and search warrant, and the rules in conducting search and seizure. Okay, so let's begin. Let's begin the discussion with a question: what is arrest? So, arrest is the taking of a person into custody in order that he may be bound to be uh, he may be bound to answer the commission of the offense, and that is found in section 1 of rule 113 of the rules of court. And it is again it is defined as the taking of a person into custody in order that he may be bound to answer for commission of offense, and this is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making arrest. So arrest is may be considered as the most controversial and well-known function of police officers. So that's one of the function or rules or duty of a police officer is that is to arrest. So what is the manner of conducting arrests? Now, arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. So, will force or violence may be employed in the conduct of arrests? Well, force or violence may be employed when necessary in the conduct of arrests. So, no violence or unnecessary force shall be used in making an arrest, and the person arrested shall not be subjected to a greater restraint than is necessary for his detention. So that's in section 2 of Rule 113 in the Rules of Court. Now, what is the rule? What the rule is prohibited is the unnecessary force or the violence. If the employment of such force or violence is necessary to secure the conduct of arrest or to secure the life or limb of the person making the arrest or other person, then uh, that is allowed. Okay? So search as an incident of arrest. Search as an incident of arrest is that the person making the arrest may conduct bodily search against the arrested person to confiscate the following. So he may confiscate objects or subjects of the offense or use or intended to be used in the commission of the crime, objects which are the fruits of the crime, and objects which are illegal per se, and also those which might be used to commit these violence or to escape dangerous. There is a presence of dangerous weapon and the evidence of the case. So what is the duty of the arresting officer? So the duty of this arresting officer is he will going to, or it shall be the duty of the officer executing the warrant to arrest the accused and deliver him to the nearest police station or jail without unnecessary delay. That's section 3 of Rule 113. Okay, so again, that person or that arrested accused must be delivered to the nearest police station or jail without unnecessary delay. Okay, so what is warrant of arrest? We were talking a while ago of between warrant of arrest and search warrant. So what? Let's start first. Answering the question, what is warrant of arrest? Well, warrant of arrest is, take note, an order in writing issued in the name of the people of the Philippines, signed by the judge, and directed to a peace officer, commanding him to arrest a person or persons stated therein and deliver them before the court. So, these warrant of arrest will be executed within 10 days from its receipt. Okay? Now, what is the requisite or the requirements of a valid warrant of arrest? Now, first is that it shall be issued upon probable cause. Okay? So the probable cause is also determined personally by the judge upon examination under oath or affirmation of the complainant and the arrest he may produce. And also particularly describing the person to be arrested. That's in section 2 of Article 3 of the Philippines Constitution. So, what is the lifespan or the duration of the warrant of arrest? Now, as long as the person stated in the warrant of arrest is not arrested, then it shall remain valid even if several years already lapsed. Okay? Okay, so the head of the office to which the warrant of arrest was delivered from for the execution shall cause the warrant to be arrested within 10 days from its receipt. So 10 days. And within 10 days after the expiration of the period, the officer to whom it was assigned for execution shall have a report to the judge and who issued the warrant, and in case of his failure to execute the warrant, he shall state the reason for its non-execution, but the validity of the warrant is not affected. Okay, that's in section 4 of rule 113 of the rules of court. Now, what is the exemption of the arrest by virtue of warrant? So, as a rule, no, every arrest must be done by a virtue of warrant of arrest. And what are the exemptions of these rules? No. So there are three. I think there are three. So first is that when in the presence, so exemption meaning when could be there could be a warrantless arrest. Yes, warrantless arrest. So, number one is when the presence of the arresting person, the person to be arrested committed, is actually committing or is attempting to commit an offense. Okay? So, that is what we called in flagrante delicto arrest or caught in the act, no? That you have witnessed such crime or such behavior or a certain action, no, that would cause a certain person to be in pain or to be to commit an offense to the other person. So when we say in flagrante delicto arrest, it lies in its Latin origin, which in the law it refers to the catching of someone in the act of something like a crime, no? And in flagrante delicto arrest, in flagrante delicto and in flagrante are additional ways of describing such situation. No, for example, the flagrante delicto exists when a convenience store or convenience store staff comes back from the bathroom, no, to a and then when he came back to the bathroom, he find a robber or potan stealing money out of the cash registry or the cash box, no? So to explore this concept, okay, so nasakpan niya man. So to explore this concept, considering the following, it is a flagrante delicto definition. So in flagrante delicto warrantless arrest, it should comply with the element of immediacy, no, between the time of the offense and the time of the arrest. For example, in one case, the Supreme Court held that when the warrantless arrest was made 3 months after the crime was committed, then the arrest was unconstitutional and illegal. Okay, so again, um, when the warrantless arrest was made 3 months after the crime was committed, no, as from its word caught in the act, it should be on that time, on that day, on that particular moment. No? So at that the example wherein the arrest was made 3 months after the crime was committed is unconstitutional arrest, or is illegal. Okay, and if the accused is caught in flagrante delicto, then the warrantless arrest is lawful, and the evidence obtained in a search incidental to the arrest is admissible in court as evidence. And one common example of also of warrantless arrest is the buy bust operation. Okay, and the offense is committed in the presence of or in the presence or within the view of an officer, or when an officer sees the offense, although at a distance, no, or hears the disturbance that it creates, and proceeds at once to the crime. So if the warrantless arrest turns out to be unlawful, still the court is capable of assuming this jurisdiction over the accused. Now, any objection to the court's jurisdiction is waived when the person arrested submits to arraignment without any objection. The uh, the test of the in flagrante delicto arrest is that the suspect was acting under the circumstances reasonably tending to show that he has committed or is about to commit a crime. So, evidence of guilt is not necessary. However, it is enough if there is a probable cause. No? For example, if there is probable cause, there was a prior arrangement to deliver shabu inside a hotel, and then the immediate warrantless arrest of the accused upon his entry in the hotel room is already valid. And then, by contrast, the discovery of marked money on the accused does not justify a warrantless arrest. Okay? So, another is when the offense has just been committed. So, meaning, nahuman na, mopay pagkahuman, and the arresting person has probable cause to believe based on the personal knowledge of facts and circumstances that the person to be arrested committed it. Now, under this rule, it is called the hot pursuit arrest, or arrest in hot pursuit, wherein the policeman should have the personal knowledge that the suspect committed a crime. So the test is probable cause, which the Supreme Court has defined as an actual belief or a reasonable grounds of suspicion. So under this rule, the policeman does not need to actually witness the execution or the acts constituting the offense, but he must have direct knowledge or view of the crime right after its commission. So that is for the hot pursuit. Now, Another exemption of the arrest by virtue of warrant is when the person to be arrested is a prisoner who has escaped from a prison establishment or place where he is serving final judgment or is temporarily confined. So this is known as the fugitive of justice or escape. So arrest of an escape or escape. So na priso na and then iikya. So then you can arrest that person without warrant of arrest. Okay. So the exemption of arrest by virtue of warrant in cases falling under the paragraph A and B, the person arrested without a warrant shall be forthwith delivered to the nearest police station. So, if a certain crime happens in Balilihan, then happens in the area or jurisdiction of Balilihan, then the officer or the person who arrested the offender or the suspect or the accused will will be on even if he came from Corelia or he lives in Corelia, the crime happened in Balilihan. Therefore, the nearest police station is in Balilihan, right? Because the crime happened in Balilihan man. Okay, or these will then undergo a preliminary investigation or inquest proceedings, which will later you will know what are those things. Now, that is a section in section 5 of Rule 13 of the Rules of Court. Now, the enumerated instances no, are also known as the warrantless arrest or citizen's arrest, which are the instances when a private person may conduct arrest and the private persons cannot serve a warrant of arrest because to arrest a person by virtue of a warrant is an exclusive authority of only the police officers. So that's another thing. Now, so example of that is when you are walking along Tagbilaran City and then you saw or you have witnessed the person stealing uh, or yeah not stealing, let's say transferring sachet of shabu to another person, and then you have witnessed that one, then what did you do? You try to arrest that person by means of telling, or maybe you telling that the person is having a shabu, or if it is theft or robbery, you witness that the bag is open, and you you went to the police no you went to police station, or you immediately arrest that person, and then na-caught in the act nimo siya nga na kuan by opening your bag, and then you immediately reported it to the police station. So this that is a warrantless arrest, and then the private person cannot serve the warrant of arrest because again the arrest of a person by virtue of a warrant is an exclusive authority of the police officers. Okay. So other grounds of warrantless arrest under the other than those provided under section 5 of rule 113 is that when a person previously lawfully arrested escapes or rescued under the rules, and any person may immediately any place within the Philippines and then arrest by the badsman for the purpose of surrendering the accused, and where the accused attempts to leave the country without permission of the court. So these are on kanang mga naipending nga mga cases, na mga pending nga mga issues na daan. And then the general rule, that just take note that the general rule as regards to arrests and searches and seizure is that the warrant is needed in order to validly effect the same. The constitutional prohibition against unreasonable arrests, searches, and seizures refers to those affected without a validly issued warrant. So, the doctrine is that a warrant of arrest is required before an arrest is made. So, a warrantless arrest are the exemptions. Now, there are other grounds for the warrantless arrest under those provided under Section 5 of 112. So that was what I've mentioned a while ago, which is you can see in your screen also. So these are some of the other grounds for warrantless arrest. Now, when is the perfect time in making an arrest? So there is no perfect time in making arrest, no definite time. So unlike in a search warrant, which may be served in daytime, unless specifically allowed by the warrant to be executed day or night, arrest may be made on any day at any time of the day or night. So that's Section 6 of Rule 113. And these are the methods of arrest, no? With a warrant by a police officer, without warrant by police officer, or arrest by private person or citizens arrest. Now, with a warrant by police officer, um, that is when an arrest by virtue of warrant. The officer shall inform the person to be arrested of the cause of the arrest, and the fact that the warrant has been issued for his arrest. So, except when he flies or forcibly resists before the officer has the opportunity uh, to inform him, or when the giving of such information will imperil the arrest. Now, the officer need not have the warrant in his possession at the time of the arrest, but after the arrest. So, if the person arrested requires it, then the warrant shall be shown to him as soon as practicable. So that is with a warrant by police officer. Then, without warrant by police officer, so when making an arrest without a warrant, the officer shall inform a person to be arrested of his authority or his rights and the cause of the arrest. So, unless the latter is either engaged in the commission of an offense, is pursued immediately after its commission, has escaped, flies, or forcibly resists before the officer has opportunity to so inform him, or when the giving of such information will imperil the arrest. And then arrest by private person, or the citizen's arrests. So if the citizen's arrest, when making an arrest, a private person shall inform the person to be arrested of the intention to arrest him in the case of the arrest, unless the latter is either engaged in the commission of an offense, is pursued immediately after its commission, or has forcibly resist before the person making the arrest has the opportunity, so inform him when the giving of such information will imperil the arrests. So what if the person lawfully arrested escapes? So if a person lawfully arrested escapes, any person may immediately pursue or retake him without a warrant, at any time and in any place within the Philippines. Okay, so this is known as the hot pursuit or also called the fresh pursuit. Okay, and what are the rights of police officers conducting arrests and what are the rights of the arrested person? So when may the arresting officer summon the assistance? So an officer, the rights of the police officer, he has the right to summon the assistance. They have has the right to break into building or in enclosure, and then the right to break out from building or enclosure. So when may the arresting officer summon the assistance? The officer making a lawful arrest may orally summon as many person as he deems necessary. So that is to assist him in effecting the arrest. So every person so summoned by any officer shall assist him in effecting the arrest when he can render such assistance without detriment to himself. So take note that any person coming to the aid of the agent of person in the authority, such as police officers, and such person coming to the aid is assaulted, then the perpetrator is liable for indirect assault as provided under Article 149 of the Revised Penal Code. And then rights of the arresting officer to break into and break out. So A and B and C. So the right of the officer to break into building of or enclosure is that in order to make an arrest, either by virtue of a warrant or without a warrant as provided in Section 5, it may break into any building or enclosure where the person to be arrested is or reasonably believed to be if he is refused admittance thereto after announcing his authority and purpose. And then the requisites are the following. So the person to be arrested is reasonably believed to be in the building, and that he announced his authority and purpose for entering therein, and he has been denied admittance. And then right to break out from building or enclosure is that when the officer has entered a building or enclosure in accordance with his right to break into building or enclosure, and he may break out therefrom when necessary to liberate himself. Now, these rules or rights are allowed only to police officers and not to private person making a citizen's arrest. So take note of that it is only allowed for the police officers. Now the rights of the arrested person. Now the rights of the arrested person is number one is the rights against torture against torture, force, intimidation, and the like. So any member also of the Philippines bar shall, at the request of a person, the person arrested or of another acting in his behalf, have the right to visit and confer privately with such person in the jail or in any other place of custody at any hour of the day or night. Now, that is subject to reasonable regulations. A relative of the person arrested can also exercise the same right. So that's in section 14 of Rule 113. 113. Now, a person not subject, note that the person not subject to arrest, a senator or a member of the House of Representative shall, in any offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress is in session. Now, no person also no person member shall be questioned or be held liable during the for any speech or debate in Congress or in any committee thereof, and also immune from arrest are ambassadors and ministers of the foreign countries in the Philippines, in accordance with the Republic Act number 75, which provides that the any writ of the process sued out or prosecuted by any person in any court of the Republic of the Philippines or by any judge or a justice whereby the person of any ambassador or a public minister of any foreign state authorized and received as such ambassador or minister is arrested or imprisoned, or his goods or chattels are drained, seized, and attached, and shall be deemed for void, and every person by whom the same is obtained or prosecuted with whether as a party or attorney, and every officer concerned in executing it, and shall upon conviction be punished by imprisonment for more than 3 years and fine of not exceeding 200 pesos in the discretion of court. So, what are the crimes that may be committed by a police officer while conducting arrest, whether with or without warrant? So, one of the crimes that committed by certain police officer is the delay in the delivery of the arrested person to the proper judicial authority. Now, this is committed by public officer or employees who shall detain any person for some legal grounds and shall fail to deliver such person to the proper judicial authorities within the following periods. We have 12 hours for crimes or offenses punishable by light penalties or their um, uh, equivalent, and then 18 hours, and also 36 hours for capital penalties. Take like for example, a policeman arrested a person uh, for the crime of rape, which is punishable by an effective penalty. So in such case, the arrested person must be charged before the court of the crime of rape, within 36 hours from the arrest. Otherwise, the arresting officer will be liable for arbitrary detention. So take note that the proper designation of crime committed by a public officer who delays in the delivery of arrested persons to the proper judicial authority is what we call as arbitrary detention. So, what are the crimes that may be committed by a police officer while conducting arrests? Another is the unlawful arrest. So, unlawful arrest is committed by a person who, in any case other than those authorized by law, shall arrest or detain another for the purpose of delivering him to proper judicial authorities. Now, um, an example of this is a policeman was inviting or investigating a crime which was just committed to determine the identity of the perpetrator. So when he saw a suspicious looking person walking across a street, afterwards the policeman arrested the person and then delivered him to the nearest police station and filed a criminal case, and then uh, even if uh, even if he knew that there was no sufficient evidence to prove or sufficient evidence which may show that the arrested person was the one who committed a crime being investigated. In this scenario, we would in this scenario, the policeman or policeman may be liable for the crime of unlawful arrest. Now, what if the arrest is not authorized by law and the person arrested to deliver to any uh, to any place aside from jail or police station. So if the arrest is not authorized by law and the person was delivered to any other place aside from jail or police station, that person will be liable also for the crime of kidnapping. Okay? Now, take note that if the arresting person detains the arrested person without any legal grounds, he is liable of either illegal detention or arbitrary detention. So, um, illegal detention meaning if the detaining person is a private person. The arbitrary detention is if the detaining person is a public officer or employee. Now, so another question is that if what if the arrest is not authorized by law and with lewd design? So lewd design means lust or wag or offensive sexual behavior na ikanang motive to have sexual act. And there is lewd design if the arresting person has the intention to have sexual intercourse with the arrested person. So this arresting person may be charged of forcible abduction. Okay. So another is expulsion. Expulsion is any public officer or employee who, not being thereunto authorized by law, shall expel any person from the Philippine Islands or shall compel such person to change his residence. Example of this is a policeman arrested a person in Tagbilaran City and then delivered him, no, from Tagbilaran City. That arrested person was being delivered to the Cebu City, to Cebu City. So directing the latter that it is better if he is going to reside in that place. So that's another crime that could be committed by a police officer, and this is common, especially if the police officer is a friend of the arrested person. So that is expulsion. Then we have also search and seizure. Search means define an act of looking into carefully in order to find some concealed items, diba? Search. We wanted to see, to look for something. Seizure is the taking into custody of something, confiscate or something like that. So what is search warrant? Search warrant is an order in writing issued in the name of in the name of the people of the Philippines, signed by the judge and directed to a police officer, commanding him to search for a person, property described therein and bring it before the court. So, commanding him to what? To search for a personal property described on the given on the uh, describe there in the given search warrant and bring it before the court. So, what is the elements of search warrant? So, number one element of search warrant is the written order. There should be a written order, and it should be signed by judge in the name of the people of the Philippines. And there is a commanding peace officer to search personal property, and that search and bring such personal property to the court. So you can relate this one to the Article 3 of the 1987 Constitution, which is the Bill of Rights. The requisite of a valid search warrant. So, a search warrant shall not issue except upon probable cause in connection with one specific offense to be determined personally by the judge, And then, after examination under oath or affirmation of the complainant and the witness, he may produce and particularly describing the place to be searched and the things to be searched, which may be anywhere in the Philippines. So, take note that the judge must be, before issuing the warrant, personally examine the form of searching questions and answers in writing and under the oath. And then the complainant also and the witnesses may produce on facts personally known to them and attached to the record, their sworn statements together with the affidavits that have been submitted in the court. So what is the subject of search warrant? No, the subject of search warrant is the subject of the offense, the stolen or embezzled or other proceeds or fruits of offense, and used or intended to be used as means of committing a crime. Now, there are two kinds of property. One is real property and personal property under the warrant of arrest, a search warrant. Sorry. So the real property, these are this refers to those who cannot be transferred from one place to another. Example of these are lands, buildings, roads, and others. Now, for personal property, these are those which can be transferred from one place to another. Like, for example, ammunition, firearms, knives, clothes, and the like. So, these are the personal property. And it must also be stressed further that there is a need for a policeman to be armed with search warrant, no, when conducting search, unlike when conducting arrest. So there must be they should be armed with search warrant when conducting search. Unlike with the warrant of arrest, they can have the warrantless arrest. Pero kaning search warrant or search and seizure, you must have the search warrant, to get inside a certain house if there is a search warrant looking for something or an item needed in order to prosper the certain um, crime or a certain investigation or something like that. Okay. So, what is the lifespan of a search warrant? A search warrant shall be valid within 10 days from its date. So, thereafter, it shall be void. So, it will not invalid after 10 days already. Invalid na siya after 10 days. Now, where do we file search warrant? So, search warrant is filed in any court within those territorial jurisdiction a crime was committed. So any court within the judicial region where the crime was committed, and if the place of the commission of crime is known, or any court within the judicial region where the warrant shall be enforced. So that is the application for search warrant, where you can file the application for search warrant on court and in any court within those territorial jurisdiction and within the judicial region where the crime was committed. Now, for compelling reasons also, um, for compelling reasons stated in the application, any court within the judicial region where the crime was committed, if the place of the commission of the crime is known, or in any court within the judicial region where the warrant shall be enforced. However, if the criminal action has already been filed, the application shall only be made in court where the criminal action is pending. So when do we serve search warrants? The search warrant must be direct that it be served in the daytime, unless the affidavit asserts that the property is on the person or on the place ordered to search, in which case a direction may be inserted that it may be served at in any time of the day and night. But if the judge is satisfied of the existence of facts upon which the application is based, or that there is a probable cause to believe that they exist, then he shall issue the warrant. So rights to break door or window to effect search. So the officer, if refused admittance to the police or directed search after giving notice of his purpose and authority, may break open any outer or inner door or window of any house or anything wherein the to execute the warrant to liberate himself or any person lawfully aiding him when unlawfully detained therein. Sorry. So the two witnesses rule. So no search of a house or room or any other premises that shall be made except in the presence of the lawful occupant. So there or any member of his family or in the absence of the latter. So two witnesses of sufficient age. So sufficient age meaning it is can able to know what is right and what is wrong already, maybe 18 legal age, and the discretion residing in the same locality. Now, the receipt for the property searched. So, the officer searching the property under the warrant must give a detailed receipt from the same to the lawful occupant of the premises in which the presence of whose presence the search and seizure were made, or in the absence of such occupant, must, in the presence of least two witnesses of sufficient age and discretion residing in same locality, leave a receipt in the place in which he found the seized property. Okay. So delivery of property and inventory thereof to court, and return and the proceeding thereof. So the officer must forthwith deliver the property search to the judge who issued the warrant, together with the true inventory thereof duly verified under the oath. And then 10 days after issuance of the search warrant, the issuing judge shall ascertain if the return was issued, and require him to explain why no return was made. So if the return has been made, the judge shall ascertain whether Section 11 of this rule has been complied with, and shall require that the property seized be delivered to him. So the judge shall see it to the subsection, and there hereof has been complied with, and then the return on the search warrant shall be filed and kept by the custodian of the logbook on search warrants, who shall enter wherein the date of the return and the result and other actions of the judge. So, in the delivery of property and inventory, if this will not be executed, then a violation of this shall constitute contempt of court. The rule in conducting search and seizure. So one no, the one rule in conducting search and seizure is the consented search. Consented search is that the right against unreasonable search and seizure may be voluntarily waived by a person being searched, provided the following are present: existence of a right, the person has knowledge, either actual or constructive, of the existence of such right, and that the said person had the actual intention of of relinquishing such right. So example of this is a person, no, suspected of possessing illegal drugs, who was being tailed by a policeman. So, sensing that he was being tailed, he confronted the policeman in civilian clothes, saying that I am not a criminal, and I am not doing something wrong. To now to prove that I am a law-abiding citizen, search me. He said that one. And because of what the person said, the policeman, of course, searched him, and they found out two sachets of methamphetamine hydrochloride, or shabu, or otherwise known as shabu, in his pocket. Now, in this case, the illegal article may be used against the person searched because he consented. Consent. He consented the search. Okay, so that's consented search. Another is search incidental for lawful arrest. Now, a person lawfully arrested may search for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. Now, take note that in several cases, the Supreme Court has held that arresting officer may also seize prohibited articles, and these items are considered as illegal per se. Even if it is not included in the search warrant, for as long as the search warrant is valid, and if the search warrant is later on quashed, the court may forfeit such items, and the arresting officers are not required to return the prohibited articles. So other valid warrantless searches and seizures are, uh, again, those incidental to lawful arrest, searches in plain view, searches of moving vehicles, consented searches, custom searches, stop and freeze situation, and searches during insurgencies and emergency. Now, in search incidental for lawful arrest, example of this is a policeman caught in the act, a man stabbing a woman. Now, in that instant, the police may arrest and search that man even without warrant to do so, because that is caught in the act, di ba? Flagrante delicto. At the same time, to testify that that person stabbed the woman, the weapon, or the weapon that he used in stabbing that person may be used against him, as because that will be searched, no? So and that will be confiscated. So that is search in incidental for a lawful arrest. Then plain view search. The plain view is the illegal things that sight may be seized even without a warrant to do so. The things may be readily seen without any effort of locating it. So, without any effort of locating it, that is plain view search. No, the authorizes a search and seizure without a warrant. So, requisite of these are that there must have been a legal presence in the place where the search is made. The evidence was discovered advertently by an officer with a right to be where he is. The evidence is immediately apparently illegal, and there is no need for any other further searches to obtain the evidences. No? And after the warrant squash, contrabands and illegal items found in plain view during the search should not be returned. So di na mauli siya. And the possession of the same should be kept in custodial leges. For example, a policeman was conducting patrol when he saw a gunman, held by a person whom he believed to be a policeman. No, he was believed to be a policeman. Now, in such case, no, the policeman may inquire about the license, no, or the other documents pertinent to the lawful possession of that handgun. No? Now, in case no document is presented, then that person may be arrested and his gun may be searched. Okay, so that's plain view search. Um, Another is the search in moving vehicle. A search in moving vehicle is that it is made during checkpoints, no, and that is shall be limited to visual search. Neither the vehicle nor the occupants shall be subjected to physical search or require the passengers to alight from the vehicle. Now, an extensive search may be allowed only if the officer conduct uh, a search that has probable cause to believe that they would find evidence pertaining to the commission of a crime in the vehicle to be searched, and there is no sufficient time to secure a valid warrant upon which the passenger shall be required to alight from the vehicle to effect the search. Now, a person, example of this is uh, the person, no, a person driving the car that is not his, and the said car was searched, the driver cannot assail the legality of the search and seizure on the ground that he is not the owner of the car and has no bearing on the legality of the search. So muna if that person is not the owner or is not his or the said car was searched and the driver cannot is not the owner of the car, then there's no bearing on the legality of the search. Another is custom search. So custom search is the personnel of Bureau of Customs, no, conduct search to enforce custom law or to regulate export and import. So these are example of custom search. Stop and frisk situation. Now, this is limited protective search of the outer clothing of a person to determine the presence of a weapon. So when you go to mall, there is a stop and frisk practice, right? Now, probable cause is not required, but a genuine reason, not it in the light of officers' experience and surrounding circumstances, to the warrant, they believe that the person has concealed weapons. Now, a search warrant may not be a ground on that there is an error in the same name the accused in search warrant, and it is not necessary that a particular person name in a search warrant. Now, crimes may be committed by a policeman while conducting search. No, we have violation of domicile. Violation of domicile. Example of this is when Police Corporal Chududu, being authorized by a judicial order, secretly entered the dwelling of Mr. Shaolin. No? So secretly entered the dwelling. Now, he may commit the crime of violation of domicile if he performed the following, no, he secretly entered a dwelling without being authorized by judicial order, and he searched paper or other effects found therein without the previous consent of the owner, and he was required to leave said premises but refused to do so. And then we have search warrant maliciously obtained. One illustration of this is that a police officer applies for a search warrant and intentionally lied in his affidavit. No, basing on said affidavit, the judge issued a search warrant. No, this is committed by public officer or employee who procures a search warrant without just cause. Abuse in the authority of search warrants legally obtained. Now, this is committed by public officer or employee who has legally procured a search warrant but exceeds the authority of search warrant, or he used unnecessary severity in executing the same. So example of this is a public officer executing a search warrant for opium or size books or personal letters and other property not related to opium. Okay, so that's another example. Searching domicile without witnesses. On this certain crime committed by policeman while conducting search, example of this is a policeman armed with search warrant legally procured searches the house of a person without an owner. No, but in the presence of a without the owner, uh, but in the presence of a 7 years old child of the owner. No? So that is searching domicile without witnesses. Why? Because the 7-year-old child is not sufficient, is not a sufficient age. No, any member of the family, at least two witnesses residing in the same locality, refers to a person of sufficient age and discretion. So a person is considered sufficient age if he attains the age of majority or 18 years old, and he is of sufficient discretion, and if he is sane. So that is another crime committed by policemen. Now, the distinction between warrant of arrest and search warrant is that both of them are orders. No? They are the warrant of arrest and search warrant are both orders in writing issued in the name of the people of the Philippines and signed by judge. These are the similarity, and it is directed to the police officer. And also, the warrant of arrest and search warrant are issued only upon probable cause. Now, the warrant of arrest is intended only, the difference between warrant of arrest and search warrant is that the warrant of arrest is intended only to arrest a person, while a search warrant is intended to search and seizure things specified therein. Okay, see the difference between person and things. And also, the warrant of arrest remains valid as long as the person stated therein is not arrested, regardless of the number of days that already lapsed. While the search warrant is valid within 10 days from issuance. Now, the warrant of arrest may not be in possession of the arresting person when conducting arrest. Okay. While the search warrant must be in the possession of the police officer when conducting search and seizure. And the warrant of arrest may be executed any day and time, any day and night, while search warrant, as a rule, must be executed during daytime only. Okay? So, in responding to crime, no, this is very this is um, a very good question. No? In responding to crime scene, what must be taken into consideration for a policeman when you become a police officer soon, or when you become part of the law enforcement agency? What should must be taken into consideration by a certain policeman before um, before apprehending a criminal and preserving the evidence? The first thing that you should do is to save life first. Okay? Save life first. So, if you witness a certain crime or an incident, save life first before apprehending the criminals and preserving the evidence will be the next priorities. Okay? So, I hope you. These are the topics that we have in the law enforcement pillar, and I hope you had a great time, and you have the knowledge now. The You have a lot of things now. To You have a lot of knowledge, ideas, no, um, on the law enforcement pillar. Okay. Now these are my references. I have also e-resources which I did not able to add on, although these are in APAP format also. And yeah, so these are all the law enforcement pillar. And on next meeting, we will discuss the prosecution pillar of the Philippine criminal justice system. Um, I will see you on my next discussion, and I stay safe always, and let us all continue to pray that this pandemic will end so that we will be able to see each other very soon. So for that, class dismiss. Bye everyone. Have a um, happy and fruitful day onwards. Bye.